The issue in these proceedings have nothing to do with whether the UK should exit from the EU or the terms or timetable for that exit. The main issue is whether the government can trigger Article 50 without the prior authority of an Act of Parliament. The other issues concern the obligations of the UK government under the devolution legislation before triggering Article 50, and in particular, whether the legislatures in Scotland, Wales and Northern Ireland must be consulted. So far as the main issue is concerned, as a general rule, the government has a prerogative power to withdraw from international treaties as it sees fit. However, the government cannot exercise that power if it would thereby change UK laws, unless it is authorised to do so by Parliament. The claimants argue that as a result of leaving the EU, UK law will change and legal rights enjoyed by UK residents will be lost. Accordingly, they say, the government cannot trigger Article 50 unless authorised by Parliament. In reply, the government argues that the 1972 Act does not exclude the power for ministers to withdraw from the EU treaties, and that Section 2 of the 1972 Act actually caters for the exercise of such a power. Today, by a majority of 8-3, the Supreme Court rules that the government cannot trigger Article 50 without an Act of Parliament authorising it to do so. Put briefly, the reasons given in a judgment written by all 8 justices in the majority are as follows. Section 2 of the 1972 Act provides that whenever EU institutions make new laws, those new laws become part of UK law. The 1972 Act therefore makes EU law an independent source of UK law until Parliament decides otherwise. Therefore, when the UK withdraws from the EU treaties, a source of UK law will be cut off. Further, certain rights enjoyed by UK citizens will be changed. Therefore, the government cannot trigger Article 50 without Parliament authorising that course. We reject the government's argument that Section 2 caters for the possibility of the government withdrawing from the EU treaties. There is a vital difference between changes in UK law resulting from changes in EU law, and those are authorised by Section 2, and changes in UK law resulting from withdrawal from the EU treaties. Withdrawal affects a fundamental change by cutting off the source of EU law as well as changing legal rights. The UK's constitutional arrangements require such changes to be clearly authorised by Parliament, and the 1972 Act does not do that.